number 4 to take away the bullock cart carefully on the ground that he has put the raw green gram for dry. Full stop. As such, enraged by the same, accused number 4 picked a row with the deceased and assaulted him. Full stop. Thereafter, the PW1 intervened and consoled both the accused number 4 and deceased and sent away from the scene of offense. Full stop. Later, the deceased Nagaya and his daughter PW3 Yankamma came and informed PW1 that accused number 1 Shivaya and his children, that is accused number 2, 3 and 4, are in search of deceased Nagaya to assault him. Full stop. PW1 also informed that the deceased Nagaya advised deceased Nagaya to stay in his house. Full stop. Since it was raining and there was a leakage in roof, PW1 went on the terrace of his house and was closing the area wherein the water was leaking. And at that time, he saw the deceased Nagaya was moving towards his house from the bus stop. Full stop. At that point of time, the accused number 1 to 4 wrongfully restrained the deceased Nagaya and picked up a row with him and started to assault him. Full stop. Immediately, PW1 got down from the terrace and went to the said place along with the daughter of deceased, that is PW4, PW3, and also along with his wife. Full stop. Full stop. In the said quarrel, CW with the accused number 1, 2 and 4 foretold the deceased, and accused number 3 stabbed him with a knife MO5.
Yes.
MO5. Full stop. They stabbed the deceased on the abdomen, chest and right side of the neck. Full stop. With the MO5.
Chest,
due
stomach,
to the injury,
stomach.
and also stomach. Due to the injuries, the deceased, the said Nagaya fell on the ground and succumbed to the injuries on the spot. Full stop. Thereafter, the accused fled away from the spot. Full stop. Subsequently, PW1 lodged a complaint before the respondent police on 14/9/2015 at about 1:30 p.m. 2:30 p.m.
Incident is
2:30 p.m. as per Exhibit P1, Exhibit P1 and Exhibit P1. Full stop. On the strength of said complaint, PW, register ಮಾಡಿದ್ದು?
PW1 ballot is.
no.
Who registered FIR?
Registered ballot is the PW21 is the CPA Balakrishnan.
PW20.
PW20.
ASI.
The then ASI of the respondent police registered the FIR in crime number 218 of 2015, dated 14/9/2015, against the accused for the offense punishable under section 302 read with 34 of IPC as per Exhibit P19.
Yes.
As per Exhibit P19. Full stop. Subsequently, PW 21, PW 21, the investigation officer in this case has conducted the investigation by drawing the spot mahazar as per Exhibit P,
Exhibit P4, 5.
Exhibit P5. So also the inquest Panchanama on
4.
4 months.
Inquest is 4, spot is 5 minutes.
exhibit spot is 5 alla.
Yes.
Spot exhibit P5. So also the inquest Panchanama on the corpus of the deceased as per exhibit P4.
Yes.
Exhibit P4, full stop. Subsequently, the PW 21, comma, recorded the statement of the eyewitness to the incident, record the statement of the witnesses, statement of witnesses, witnesses. So also, comma, obtaining the necessary documents from the concerned authority, comma, laid the charge sheet against the accused for the aforementioned offense, for the aforementioned offenses,
302.
ಯಾವುದಕ್ಕೆಲ್ಲ? For the offense punishable under section 302, 504, 120B of IPC before the committal court. Full stop. After committal of the case before the session court, the learned session judge framed the charges against accused for the aforementioned offenses and read over the same to them. However, the accused denied the charges and claimed to be tried. Full stop. Next, in order to prove the charges leveled against accused, before the session court, the prosecution has examined in total 22 witnesses as PW 1 to 22. So also got marked 29 documents
Yes.
as exhibit P1 to
P29.
P29 and got identified 5 material
to
objects as
5.
MO1 to MO5. Full stop. After completion of the prosecution evidence, the learned session judge read over the incriminating evidence of material witness to the accused as contemplated under section 313 of CRPC, however, the accused denied the same. The defense of the accused is that of one that of denial and false implication. Full stop. Post assessment next. Post assessment of the oral and documentary evidence, the learned session judge, acquitted the learned session judge acquitted the accused for the offense 504 read with 34 of IPC. However, convicted them for the offense punishable under section 302 120B read with 34 of IPC and sentenced them as stated supra. Full stop. The said judgment is challenged in this appeal by accused number 124. Full stop. We have heard the learned counsel, learned senior counsel, Shri Arun Sham appearing for the appearing on behalf of Shri Ganesh Kalaburagi.
Ganesh Naik.
Ganesh
Naik.
Naik.
Ganesh Nayak for the accused, for the appellants. So also Shri Siddhalinga Patil for the learned SP, additional SPP for the state. Full stop. It is the primary contention of the learned counsel for the appellate that the judgment under this appeal suffers from perversity and illegality since the learned session judge failed to appreciate the material evidence on record in a right perspective. He would contend that the learned session judge has failed to appreciate the aspect that the evidence of eyewitnesses in evidence of eyewitness in this case, that is PW 1, 3 and 11, PW 3 and 11, suffers from severe infirmities. The PW 1 and PW 3 have in the 1 and 3 in their cross-examination is categorically stated that they have not witnessed the incident and they reached the spot after the incident. Full stop. Moreover, the PW 11, the one more eyewitness to the incident, also admitted in his cross-examination that that PW 1 and 3 have informed him about in respect of the incident. In such circumstance, the much credence cannot be attached to the evidence of these witnesses. Full stop. He would further contend that the PW 8 and PW 9 are the hearsay witness, they are hearsay witness, hearsay witness before whom PW 1 has narrated the incident. Full stop. He would further contend that the material witness, the independent eyewitness to the incident, that is PW 4, 5 and 6 have totally turned hostile to the prosecution case. Full stop.
Even PW 9s.
And PW 9 also. Full stop. Further, the prosecution also failed to prove the recovery of the weapon which said to have used for the commission of crime by the accused number 3, since the witness for exhibit P4, the Mahazar, exhibit P11, S2,
Is the the exhibit P22 malord?
exhibit P24, witness for exhibit P24, alva? Exhibit P24.
21, 22 and 24 malord is the
Huh?
Caesar Panchanama is the 21, 22 and 24. Previous malord is the 22 is the recovery malord, the MO5 malord.
I think MO 456 ಯಾವ್ದೆಲ್ಲ ಮಾಜರ್ ಎಕ್ಸಿಬಿಟ್ ಯಾವ್ದೆಲ್ಲ
ಇಲ್ಲ malord is the one of
But exhibit MO5 is recovered under exhibit 21.
Exhibit since exhibit P21. Exhibit
Yes,
P20, the witness for exhibit P21, PW
17 and 18.
17 malord and 18 malord there is the 17.
to 17 and 18 have also turned hostile to the prosecution case. In such circumstance, the prosecution case. In such circumstance, the learned session judge has by relying the uncorroborated version of the eyewitness PW 1, 3 and 11, convicted the accused. As such, the impugned judgment is not sustainable under law. Accordingly, praised to allow the appeal. To buttress his argument, he relied the following judgments on the Napoli. Full stop. Refuting the above submission made by the learned senior counsel, the learned SPP, additional SPP, she Patil contend that the judgment under this appeal does not suffer from any perversity or illegality, since the learned session judge has passed the impugned judgment after meticulously examining the evidence on record. Full stop. According to him, the prosecution has placed sufficient evidence to prove the charges leveled against the accused. Full stop. PW 1, 3 and 11 for the eyewitness to the incident have categorically deposed that on the date of incident, the accused picked up a row with the deceased, and thereby accused number 1, 2 and 4 have held the deceased, and accused number 3 stabbed him on his person. Full stop. The full stop. The evidence of these 3 witnesses clearly corroborates with the medical evidence, that is the testimony of the doctor PW10 who conducted the autopsy on the corpus of the deceased as per exhibit P10. Full stop. Moreover, the said doctor also opined, gave his opinion as per exhibit P11 in respect of the weapon which said to have used for the commission of the crime. Full stop. In such circumstance, there is a clear corroboration to the oral testimony and the corroboration to the oral testimony to the medical evidence of placed by the prosecution. Full stop. He would further contend that the though PW 8 and 9 are 8 and 9 are not witnessed the incident, comma, nevertheless, they visited the spot soon after the incident, and the PW1 in PW1, 3 and 11 were informed them about the incident that the accused was the perpetrator of the crime. In such circumstance, their evidence has to be treated as res gestia, res gestia witness as per the provision of Section 6 of the Indian Evidence Act, Full Show Evidence Act. He also submitted the prosecution has proved the motive for the alleged incident by examining PW1 and 3. That there was a civil dispute,
Deceased and
long dispute, civil dispute between the family of the deceased and the accused.
And also as per the exhibit P29 minutes, the FSL.
Full show.
desk.
29, full show. Further, the prosecution also placed the FSL report exhibit P29, which depicts that the blood stain found on the clothes of the deceased and the MO5 weapon, MO5, the knife is of human blood of A group. In such circumstance, the prosecution has proved the guilt of the accused beyond all reasonable doubt. Accordingly, and the learned session judge rightly convicted the accused for the charges leveled against them. Full stop. Accordingly, he prays to dismiss the appeal by confirming the impugned judgment. Full stop. Having heard the learned counsel for the respective parties, so also perusal of the entire evidence and materials placed before us, the point that would arise for our consideration are: number one, perversity or illegality; number two, whether the session judge justified in convicting the accused for the offence charged. Full stop. The next, in order to full stop, though the prosecution has examined as many as 20. How many witnesses in total?
22.
As many as 22 witnesses in the case on hand, case on hand, it's not, it is not necessary to discuss the evidence of all the witnesses. Suffice to discuss the evidence of material witness to dispose this appeal. Full stop. In order to prove the homicidal death of the deceased, the prosecution predominantly relied the evidence of Dr. P.W. 10, who conducted the autopsy on the corpus of the deceased as per exhibit P10. Full stop. On peruse exhibit P10, the doctor has opined as to the cause of death is death due to multiple injuries causing bleeding and cardiorespiratory failure. Full stop. The doctor has also given the opinion that the injuries found on the corpus of the deceased could have been caused by MO5, the knife as per exhibit P11. Full stop. Nevertheless, the prosecution also placed the inquest Panchanama conducted on the corpus of the deceased as per exhibit P4 by PW21, the investigation officer.
Yes.
Investigation officer. Full stop. PW2 is the witness for the same. Full stop. The PW2 and PW21 were identified the injuries on the corpus of the deceased. In such a circumstance, corpus of the deceased. As such, a conjoint reading of the evidence of PW10, the doctor, PW21, the investigation officer, PW2, the punch witness for exhibit P4, along with the exhibit P10 and P4, we are of the considered view that the prosecution has proved the homicidal death of the deceased beyond reasonable doubt. Full stop. To connect the accused in the homicidal death of the deceased is concerned, the prosecution has mainly relied on the evidence of PW 1, 3 and 1, 3 and 11, full stop. On careful examination of the evidence of these witnesses, comma, among these witnesses, PW 1 is the complainant, who is the son of PW 1, who set the criminal law into motion and is the son of the deceased.
Brothers. Deceased brother's son,
He is the
elder brothers.
yeah, he is the son of deceased
Elder.
elder brother, full stop. According to him, on the date of incident, that is on 14/9/2015, 15 at about 1:30 PM, comma, the accused number 124, accused number 124 picked up a row with the deceased and accused number 1, 2 and 4 have held him and facilitated accused number 3 to assault him. Accordingly, accused number 3 assaulted the stabbed the deceased with MO5 knife on his person, full stop, person. Thereafter, due to the assault, the deceased fell on the ground and succumbed to the injuries, full stop. Thereafter, accused fled away from the spot, full stop. Full stop. Though PW1 reiterated the contents of Exhibit P1 is complaint before the in his evidence, comma, in his evidence on perusal of his cross-examination, comma, he has examination, he has categorically admitted that after the when he reached the spot of incident, comma, the entire incident, the accused incident, the deceased was already fell on the road, alva, on the ground, and he had already sustained injuries and was lying on the ground, full stop. He also admitted in his cross-examination that when he reached to the spot of incident, the accused were not there and already they were already escaped from the spot, full stop. Full stop. Full stop. This version of full stop from the spot. The PW, one more eyewitness to the incident, that is PW3, who is none other than the daughter of the deceased, also is deposed similarly to that of PW1 and stated in her chief examination that he witnessed the incident of assault made by the accused to the deceased, full stop. However, once in her cross-examination, she also stated that the accused, the incident was almost the incident was caused when she reached to the spot, full stop, reached to the spot. Further, the PW11 reached to the spot, full stop, hashtag. Hence, there is a clear contradictions in respect of the evidence, of PW1 and 3, and the contents of Exhibit P1, full stop, P1, full stop. Further, PW11, one more eyewitness to the incident also stated that, comma, also admitted in his cross-examination, that, comma, PW1 and PW3 have informed him, narrated the incident to him after the incident. full stop, after the incident. Though he has stated in chief examination that he has witnessed the incident, comma, in the cross-examination, he has categorically stated that the entire incident was over while he was reached to the spot of incident, full stop, spot of incident. Hence, the version of these three eyewitness, comma, creates a doubt in the mind of this court in respect of their presence in the scene of occurrence, at the time of incident, full stop. No doubt in their evidence, it could be concluded that these witnesses have reached the spot immediately after the incident, and they shifted and subsequently PW1 has lodged the complaint. But as far as their testimony in respect of they witnessing the incident is under cloud, full stop. Full stop. Full stop. Though the prosecution has examined PW 4, 5 and 6, the independent eyewitness to the incident, comma, all these witnesses have totally turned hostile to the prosecution case, full stop. Prosecution case, full stop. PW further PW 8 and PW 9 were the relatives, their relatives.
There is relative.
The relatives of the deceased are examined, comma, however, they are the hearsay witness to the incident, and according to them, PW 1, 3 and 11 have informed them about the incident. In such circumstance, comma, as held by the Honorable Apex Court in the Caton of Judgment, the evidence of hearsay witness cannot be considered for the purpose of proving the charge against the accused without any the evidence of the hearsay witness has to be cannot be relied unless there is a corroborative evidence to that effect, full stop, to that effect. In the case on hand, since as discussed in Supra, the evidence of PW 1, 3 and 11, 1, 3 and 11, the eyewitness to the incident itself not trustworthy to believe, comma, as such, the evidence of PW 8 and 9 also cannot be relied to prove the guilt of the accused, full stop, accused. As per the other circumstances concerned, comma, on perusal of evidence of PW 1, 3 and 11, comma, they have as per the other circumstance, the recovery of the MO 4 to MO 3, 4 and 5 are concerned, comma, the exhibit P20, P21 and P22, the Mahazers, the witness for the same, that is PW
17, 18.
17 and 18 are totally turned hostile to the prosecution case, full stop. In such circumstance, comma, the recovery at the instance of accused also not proved beyond reasonable doubt by the prosecution within the ambit of section 27 of Indian Evidence Act. The Honorable Apex Court in the case of Subramania versus State of Karnataka reported in 2000. Yes. Volume 11 SCC 255 held in paragraph number 78 as under. ಅದನ್ನ ಹಾಕೊಳ್ಳಿ.
76 to 84.
76, 78 ಹಾಕೊಳ್ಳಿ. Full stop. The on full stop. The on careful perusal full stop, and careful perusal of the other materials placed by the prosecution, that is the the spot hazard drawn by PW 21 as per exhibit P5. P5 ಅಲ್ಲ?
What is fine?
Exhibit P5 also P5 P5 comma the witness for the same, that is PW 2 and 3 2 and 3 are also two only two PW 2 is turned hostile to the prosecution case full show. The it is also contended by the learned senior counsel that there is a inordinate delay in transmitting the FIR to the jurisdictional magistrate
9:30. 9:30.
jurisdictional magistrate full show by the respondent police. According to him, the PW 15, the then head constable who transmitted the FIR to the magistrate, has clearly admitted that though there is a distance of 2 kilometers from the police station to the office of the learned magistrate, there is the FIR, there is a 6 hours delay. 6 hours, alla?
6 hours.
6 hours delay in transmitting.
Unexplained delay.
Transmitting the FIR. The said delay is not properly explained by the prosecution. In such circumstance, there is a doubt occurs in the genesis of the crime. Full show. Crime. The full show. The other bit full show. The crime. The other witness also. The other witness that is the other witness examined by the prosecution. That is the main evidence of PW 21. The investigation officer, investigation officer not corroborates to the testimony of PW, testimony of the eyewitness PW 1, 3 and 11, PW 3 and 11, full stop. In 3 and 11, in such circumstance, the prosecution has failed to prove the guilt of the accused, failed to prove the circumstance by placing the cogent evidence, full stop, cogent evidence. The Honorable Apex Court in the case of cogent evidence. It is the contention of the vehement contention of the learned SPP that the evidence of PW 1, 3 and 11 cannot be discarded for the reason that they are the partition witness, full stop. Artisan, and the minor contradictions in their evidence does not go to the root of the prosecution case, full stop. However, the Honorable Apex Court in the case of Darya Singh versus State of Punjab reported 1963 SCC online SC 123 held in paragraph 6 as under, full stop, as under adan full paragraph full stop. The on as discussed on careful perusal of evidence of PW 1 and 3, the 1 and 3, the incident 1 and 3, the incident as claimed by them is under serious doubt and they appears to be a planted witness to the prosecution case who appeared the scene after the incident, full stop, as admitted by them in their cross-examination, As such, we are unable to accept their testimony, full stop. Full stop. Though this case, full stop. Though full stop. Though this case is based on the evidence of eyewitness and there is the motive does not play a vital role in the vital role. However, the prosecution also failed to prove the motive for the incident by placing sufficient evidence. PW 1, 3, and 11 were not stated in respect of the motive for the commission of the incident. Full stop. It is a specific case of the prosecution that in respect of the bullocks passed on the courtyard of the deceased, and due to a cow dung, the entire incident cost, full stop. The incident cost. In such circumstance, the prosecution also failed to prove the motive for the alleged incident. The incident. It is the cardinal rule of criminal jurisprudence that the burden in the web of proof of an offense would always lie upon the prosecution to prove all the facts constituting the ingredients beyond reasonable doubt. Full stop. If there is any reasonable doubt, the accused are entitled to the benefit of reasonable doubt. Full stop. At no stage of the prosecution case, the burden to disprove the fact would rest on the defense. Full stop. The rest on the defense. Full stop. Full stop. The Honorable Apex Court in the case of Mosam Singh. Mosam Singh Roy was the state of West Bengal. Reported in 2003, volume 12, SCC 377, has made an observation in respect of the moral conviction and wandering on the strong suspicion is not an option to decide a case by the session court and held in paragraph number 27 as under. Next, as under. The golden thread which runs through the web of administration of justice in criminal cases is that if two views are possible, if two views are held on the evidence adduced in the case, one pointing out the guilt of accused and the other to his innocence, the view which favorable to the accused should be adopted. Placing reliance on the above judgments discussed above, so also on meticulous examination of the evidence comprehensively placed on record, we are of the considered view that the learned session judges erred while convicting the accused for the charges leveled against them. Full stop. Hence, interference is required in the impugned judgment passed by the session court. Full stop. In that view of the matter, these appeals succeed, and accordingly we answer the point number 1 in the affirmative and point number 2 in the negative and proceed to pass the following order. Criminal appeal number 20063 of 2020 is allowed. The judgment of conviction and order of sentence passed in SC number 17 of 2016 dated 11/2/2020 by the session judge at Yadagir is set aside, hereby set aside. Next, the appellants, accused / are acquitted for the charges for the offense punishable under section under section, 302, 120B, read with 34 of IPC. The concerned jail authority is directed to release the appellants.
Appellant number 3.
The concerned jail authority is directed to release the accused number 1, that is accused number 3. Accused number 3, that is appellate
Accused number
number
three.
3. Appellate number 3,
Fine amount.
forthwith, if he is not required in any other case. However, the bail bonds of accused number 1, 2, and 4 stands cancelled. The
Fine amount.
fine amount, if any, deposited by accused number 1, 2, and 4 shall be refunded to them on due identification. The registry is directed to communicate the operative portion of this order to the concerned jail authority.
Please.
I'm obliged, my lord, grateful.
Okay.
29,
Obliged.
Darshanyam.
Please, my lord, my lord, I interacted with my lord, my client, and my lord, we go by my lord, whatever morning order, my lords were pleased to my lord pass, and my lord, accordingly we stick on my lord, please.
So judgment is relied upon in the case of Union of India versus Alapan Bandopadhyay reported in 2022, volume 3, SCC 133.
No, I was.
This decision is relied upon by the respondents.
Correct, but I was on the point that the petition was filed challenging the validity of the notification under section 18. However, where the case could be decided only on the validity of exercise of power under 25, which is the case that is put forward by them, that the power exercise was only to transfer the proceeding akin to 24. If that were to be so, then we need not enter into validity of section 18 and leave it open and decide only on exercise of power under 25.
If your lordships don't want to decide the notification of the year 2019, then this is not a case of transfer under section 25 of the Administrative Tribunals Act, akin to section 24 of the CPC.
That's the office note that is put up. The order of the commissioner,
Yes.
chairman of the tribunal, produced.
Yes.
They produced the notings. We just have a look.
Page number 20 of that, my lords will see. Operative portion. Along with the statement of objection filed by the respondents on 18/12/2024, the entire note of the Honorable Chairman is produced.
Along with
The statement of objection.
of
The statement of objections of the respondent number 1 filed on 18/12/24.
18/12/24.
Yes.
Ah.
Page number 17, my lords will see.
Ah.
Page 17.
Yes.
Points that arise for consideration by the Honorable Chairman are as follows. Number 2, number 3, Roman number 3. In application number 2011 of 24 and connected cases, matter is seniority of RFO, which is a state cadre but pertains to Hyderabad Karnataka region. Since the learned senior counsel submitted that applicants are claiming reservation under HK region, the matter may be taken up by the Kalaburagi bench. In this matter, clarification is sought from the Honorable Chairman regarding the jurisdiction of Kalaburagi bench. Hence, the file may be placed for kind perusal of the Honorable Chairman for orders regarding appropriate bench before which the applications can be posted. It was rather, my lords, a doubt which was raised by the bench at Kalaburagi, and that doubt is answered by exercising power under section 22. And this is not a case of transfer for the purpose of avoiding any conflict of decision or anything. Then, my lords, will see the next page. Immediately on the very same page, page 17, there is a note manuscript by the registrar for kind orders. Peruse the office note, post all the above three Honorable Chairman matters before CH-2. Reduce the office note, post all the three above matters before Court Hall 2. Now that I can understand, the chairman has power to akin to what he can define as the roster. But then on section 22 of the Administrative Tribunals Act.
No, if it was in terms of the notification under section 18, then the question of filing before the other benches would not have arisen, isn't it? Because already it says some matters are exempted.
Yes.
So if at all they're withdrawing it, it should be construed to be in terms of 25.
If it is in 25, this is not the way. This probably it is not even referring to 25. 25 is a power generally which is made on the application of a party for some reasons, especially reasons like conflict of decision. Otherwise, also the chairman has the suo motu power to exercise under section 25. But this is not an exercise, suo motu exercise of the chairman. The Honorable Chairman has not suo motu passed any order. It is a reference by the bench saying that, see, these are the disputes. One person is claiming that this is an application pertaining to only Hyderabad Karnataka region. Though the cadre is RFO statewide, my application and the grievance is only related to the region, HK region alone, which is completely within the jurisdiction of the Kalaburagi bench.
But let's have a look at the petitions.
Yes.
Can we have it tomorrow?
Yes. If it is not inconvenient to the Honorable Court, can it be after 8th of this month? But tomorrow I will permit me to come online. I will.
Yes. Now the only point is, let's have a look at the prayers in the
Applications.
And in the prayer, my lord, they have challenged the very final seniority list of both the residuary as well as a parent cadre, this 371.
Submission. There is a record of the tribunal Kalaburagi bench saying that it is restricted to only HK region. That's what I read to your chips at page 17.
That is
Last time I kindly see the prayer, my lord.
tomorrow. We'll have it tomorrow.
And my lords, one thing is, my lords, the judgment in the case of Alapan Bandopadhyay is relied by the other side, saying that the chairman has powers to transfer from one bench to other. That judgment is referred to a larger bench by the Honorable Supreme Court. And the reference to that fact is recorded in another daily orders of the Honorable Supreme Court. This is in the case of the Principal Commissioner of Income Tax versus Mukesh Kumar Meena.
But if it holds the field as on date, then
it holds the field as on date. But it is referred, my lords, to a larger bench. That I can only say that. The law is both ways saying, my lord, that mere reference will not arrest the application of the principle of law.
let us tomorrow.
Great. One more aspect is, my lords, this very bench is established for the convenience of the parties of this region.
No, insofar as 18, I'm still with you on the argument that you have made, that it's for the state government. The tribunal cannot
Yes.
tinker with that power. But however, insofar as 25 is,
Please.
May I just make one submission?
Interim order may be extended. Interim order may be.
extended to the next appeal.
Lord, 29, Lord.
Yes,
Lord, morning order may be, Lord.
yes,
Lord, it may be written,
yes.
Lord, please. Madam, may I seek webcast of the order, please?
Yes.
Obliged.
May I just make one more submission, my lords?
Yes.
Malad, the other matter pertaining to transfer of from one bench to the other, Malad, I appear for the applicants in Kalaburagi and in Bangalore. Malad. There is just one, your Lordship may just add to the confusion. 25 may be dealing with transfer from court hall 2 to court hall 3, from one bench to another bench, court hall 2 to court hall 3. 18 deals with if it is allocated to Kalaburagi, Malad. The subjects, all matters pertaining to administrative tribunal arising within those districts will be decided by the bench of Kalaburagi. Then, my lords, 18 governs. 25 may be, my lords, distribution of the matters between the benches, that is from court hall 2 to court hall 3 to court hall 1. That can be transferred. But, my lords, to transfer it, my lords, from one bench, when it is allocated to a particular bench, my lords, might be only in exercise of 18 and not in exercise of 25. Of course, I am not appearing here, my lord, but just to bring it to your lordship's attention.
It is
25 may be in that context. My lords.
the doors and windows
Very well.
are open.
Submission, tomorrow's.
Yav ಹೇಳಿ.
Otherwise, I'll be in dilemma.
ಹೌದು.
That Girish Patil, my lords were telling.
ಹೇಳಿದ್ದು. ಫೋನ್ ಮಾಡಿ.
40. I'll be ready in 46 and 47, my lords.
40?
46 and 47.
ಅದೇ ಅವ್ರು ಬಂದಿಲ್ವಲ್ಲ.
ಮೇಡಮ್ ನಾಳೆ ರೆಡಿ ಅಲ್ಲ ಅವ್ರು 43 ನಾಳೆ ರೆಡಿಯಾಗಿ ಬನ್ನಿ. ನಿಮ್ಮ
43 and 47.
ನಾಳೆ ರೆಡಿಯಾಗಿ ಬನ್ನಿ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್, ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್.
ಹೇಳಿ ಸರ್.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 39 ಏನಾಯ್ತು ಮೇಡಮ್, ಅದು ಪಾರ್ಟೆಡ್ ಆಗಿದ್ದು?
39.
ಹಾ, ಈಗ ಜಸ್ಟ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಮಾಡಿದ್ರಲ್ಲ ಮೇಡಮ್,
ಅದು ನಾಳೆಗೆ ರಿಪೀಟ್ ಆಗುತ್ತೆ ಸರಿ.
ನಾಳೆಗೆ ರಿಪೀಟ್ ಆಗುತ್ತಾ? ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು.
ನೋಡಿ ಮೇಡಮ್